Thank you. This is file number 26-3669-F8. Again, we're initially here. I'm sorry, appearances from counsel.
David Denhouten on behalf of the people.
Robert Hartzell from Mr. Baxter, who joins me to my left.
All right, thank you. So initially, we're here today for a pre-trial conference. Parties have informed me they've conducted that. There's a form that they'll fill out and submit to the court clerk's office. We don't need to go over that on the record, as I typically do not unless there's some resolution. But they've told me that there is no resolution, and therefore the case will continue to be set on the court's docket for a final pre-trial conference, which should already have been set by the court's scheduling order. If it has not yet, it soon will be. Now, we also have to address here today a defendant's motion to be granted bond. And in this case, the defendant is charged with operative while under the influence as a third offense, and as a habitual offender fourth. Also has a charge for possession of meth, driving a license suspended, and operating a vehicle without insurance. All right, thank you. One moment. All right, so it looks like there was a bond violation allegation addressed when the case was down in the 84th District Court for failing to comply with random testing and then later testing positive. And then the defense has submitted a motion to modify this to a PR bond. There was a motion filed on April 20th. The court has read and reviewed that motion. There is no written response filed by the prosecution, which of course isn't needed. All right, Mr. Hartel, the floor is yours.
Thank you, Your Honor. I know they're not present today, but just so the court is aware, at all prior proceedings, my client's wife, his father, and I believe his wife's family as well has been attending for support. I don't know if ironically they might trickle in as soon as we're done with this or not, but just
we are a couple minutes early.
Just so the court is aware, he does have strong support in the community. They've always regrouped with me in the hallways, in the parking lot, things like that. They love this man and do want to see only the best for him. We, to address the elephant in the room, aren't denying that there were findings on the probation violations, but for what it's worth, if I recall correctly, that's when it was initially charged as a misdemeanor before it was increased to a felony. The charges were amended along the way. There was a bit of a backstory there that people may or may not wish to address that.
You mean, was it a drinking and driving misdemeanor?
Initially, and then charges got added along the way. I won't go into all the details of how the process was being negotiated, because there were some negotiations behind the scenes as well.
Okay.
Perhaps would be best off the record. But what I will say is that since it's been a felony, I believe it's been a remand the entire time. I do realize felonies are treated more seriously than misdemeanors, obviously, but I believe initially it was a PR bond. I don't believe he's had the opportunity at a financial bond. And the reason I say that is his family had to pool in money. These people who love and support him, give him a place to stay. That's skin in the game. I know he doesn't want to disappoint them. Not that people shouldn't appreciate PR bonds. It's a gift. Of course, it should be appreciated. But if you have all your friends and family saying, hey, we all chipped in, and not that anybody would actually put a boot somewhere, but you might be concerned about that. So what I'm saying is, if the court were to at least consider what the court considered a reasonable amount to overcome those concerns that the court no doubt has, I don't doubt the friends and family would pull all their resources together. Whether or not it would be enough to reach that amount, I suppose, might depend on how big of amount that is. But I do believe it'd be appropriate to have this be at least some type of bond other than just a remand. Thank you.
All right, thank you. Yes, sir, Mr. Denhout.
Thank you, Your Honor. The court is right. The procedural posture, there was a mistest and a positive test. So the defendant was remanded after hearing an evidentiary hearing. It did occur. Initially, this was charged as an OWI first. Initially, the people were not aware of the priors that the defendant had. So that was amended to an OWI third. We also did not have the lab result of the methamphetamine that was found in the vehicle, and we did not have the blood test results. So there was a blood draw that also tested positive for methamphetamine. So it's just different, I would argue, stronger posture at this point. The facts, without going into any detail, the facts involve a concerned citizen following the defendant's vehicle, swerving and almost going head on into a FedEx truck. And then the concerned citizen flagged down a police officer and pointed to the defendant's vehicle, and there was a traffic stop. The concern that the people have and why the people are respectively opposing the motion is the defendant does have an extensive prior criminal history. There's based upon a prior PSI, there's 23 adult convictions, at least 2 of which were possession of methamphetamine. And the guidelines, just the court has some idea. The guidelines on the current plea offer is 19 to 47. So fairly significant guidelines. And so we are respectfully opposing the defendant's motion. In the alternative, we would ask for a high monetary bond, Judge.
Okay, thank you. All right, well, the court has gone through additional portions of the court file beyond just the the bond violation issue. Which, by the way, the court noticed that the cutoff level for that is 500 nanograms per milliliter, and the defendant tested positive with 2,282 nanograms of methamphetamine. And the court is familiar with the defendant's prior history a bit, and of course, there's also reference here to prior drug convictions, obviously, because we've got habitual offender. Well, the habitual offender force don't mention it. There's not even a second or subsequent drug enhancement, but there is a 4th habitual felony enhancement, which means for both the operative while intoxicated or impaired, as well as the possession, means that the maximum punishments are now up to life or any term of years. Also, the court notes here that the defendant's got a history of not just not complying with the law, but also, when someone gets convicted of driving a vehicle without insurance and without a license, and the defendant admitted to, apparently in here, consuming prescription drugs, specifically Adderall and Suboxone, which were in his system, that's quite concerning. So the defendant's out driving vehicles. He knows he can't. And when I look at people who talk about family members helping him, I want to know, where did he get a car to drive? Was it somebody else's car? Did they let him drive a car? I don't know, but they're not doing much good here for him thus far. Now, that's not necessarily means that they have to, but with a defendant who has this criminal history, so forth, no, the court is quite concerned about protecting the defendant, but also protecting society. Again, he's driving a vehicle. This is a third or more drinking and driving or operating under the influence. And he only was doing so with these items or substances in his system. So now, should the court deny all bond? There's arguments that would suggest that. However, there's not a mandatory life. There's not a mandatory minimum of prison. But again, I also can look at the likelihood of conviction underneath Court Rule 6.106. And when I read the affidavit and complaint, which is the only source of information that I have to be able to make this determination about bond, the court is quite concerned not only for his health, his safety, that of the community, but also notes that the likelihood of conviction appears to be somewhat relatively high. And of course, it depends if there's any search warrant issues and things like that. So also the court recognizes that denial of bond completely, while that was a fair assessment by the district court, because they know it's going to be bound up to me, that's fine. So the court hereby will grant the motion in part, but not entirely. The court will set the bond at $50,000 cash as surety. The court will provide that the defendant is not to use or possess any alcohol, marijuana, or other controlled substances. If he's on prescription medications, he must use them strictly as prescribed by the provider. He is to enroll in an enhanced outpatient treatment program through community corrections. He is to be subject to random drug and alcohol testing through community corrections. I think that is sufficient. One moment. Let me take a look here. What was did he have a PR bond initially, Mr. Hartel?
That's the way I recall it, yes,
Yeah. All right.
When it was a misdemeanor, yes,
Yeah, yeah. All right. Well, again, this is no longer a misdemeanor. This is a felony punishable potentially by life. And of course, the court must assess and look at whether or not, excuse me. I'm sorry, keep in mind that the defendant is not guilty until proven otherwise. Therefore, bond is not to, or the conditions of pretrial release are not to be used as a punishment. They are not. However, they are to be used, and the court is to consider protection of the defendant, protection of society, and ensuring the defendant is compliant and appearing to court. Now that this is an entirely different case, the court is concerned with all those factors already discussed on the record. All right, so the court will modify the bond as already said, and I find it to be a fair and appropriate. Anything else, Mr. Denham?
No, yeah.
Anything else, Mr. Hartel?
No, thank you.
Hold on, Madam Clerk. I'm going to add GPS.
Location only, you're on?
Yeah, just location only. Not house arrest, it just has to be monitored. That puts an added, if there ever is a conviction and there's any tampering with the electronic monitoring device, that could result in a consecutive sentencing if that ever were to become an issue there for the court thinks it's appropriate. Thank you. We're adjourned.